Before we begin, a quick and important disclaimer. This content is provided strictly for educational, historical, and entertainment purposes. It does not constitute legal, financial, or professional advice. The laws and social norms discussed reflect a specific historical period in the United States and have since undergone radical transformations. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified legal professionals regarding any modern-day domestic or legal matters. In 1960, if you were a man living in the United States and you realized your marriage was a hollow shell, you didn't just walk into a courthouse and file papers. You were entering a legal and social battlefield where the odds were mathematically stacked against you. At the start of the decade, the divorce rate was roughly 9 per 1,000 married women, a figure that seems quaint today but represented a boiling pot of hidden misery. To get out, you couldn't just cite irreconcilable differences or a loss of love. You had to prove a crime. You had to name a villain. And if you couldn't, the state of New York, for example, would effectively force you to remain married until death, unless you could prove adultery. Imagine being trapped in a house with a person you despise, knowing that the only way out is to hire a private investigator to catch them in an act of betrayal, or worse, to stage a crime yourself. This was the reality of the pre-reform era. This deep dive is going to uncover the brutal mechanics of the 1960s divorce machine. From the secret divorce ranches of Nevada to the corporate boardrooms where a single filed paper could end a man's career faster than a felony. By understanding the architectural constraints of the past, you will gain a profound clarity on the evolution of modern masculinity and the hidden historical trends that still dictate how men navigate the legal system today. The primary obstacle for any man in the early 1960s was the concept of the fault-based system. Unlike the modern no-fault era, the law viewed marriage as a permanent contract that could only be rescinded if one party committed a marital fault. These typically included adultery, physical cruelty, or desertion. If both parties wanted out but neither had sinned in the eyes of the law, they were legally stuck. This led to a bizarre and ethically murky phenomenon known as collusion. Case studies from the era show thousands of couples who actually liked each other enough to want a divorce, but had to lie to a judge to get it. A man might hire a professional correspondent. A woman paid to be photographed in a hotel room with him, wearing nothing but a robe, while a private investigator burst in to take a flash photo. This staged evidence was then presented in court to meet the evidentiary standard for adultery. If the judge suspected the crime was staged, he could deny the divorce entirely, leaving the couple in a state of legal limbo. For the professional man of the 1960s, the organization man as described by social critics of the time, the stakes were not just personal, they were existential. In the mid-century corporate culture of companies like IBM, Ford, or General Electric, a stable home life was considered a prerequisite for leadership. A man's wife was often vetted by his superiors before he received a major promotion. Consequently, filing for divorce was often viewed as an admission of personal failure and a lack of discipline. Historical trends show that men in high-level management positions often stayed in dead marriages for decades to protect their trajectory toward the C-suite. A divorce could result in being passed over for promotions or being seen as a liability in the community. Potential outcomes for a divorced man in a small 1960s suburb often included social ostracization, as the neighborhood social structure was built entirely around couples culture, dinner parties, bridge clubs, and country club memberships that did not have a slot for a single man. If a man had the financial means but lacked the evidence for a fault-based divorce in his home state, he turned to the migratory divorce. The most famous destination was Reno, Nevada. In the 1960s, Nevada had a residency requirement of only 6 weeks. This gave birth to a massive industry of divorce ranches. A man would take a 6-week vacation from his job, live on a ranch outside Reno, and at the end of the 42nd day, he would appear before a Nevada judge who would grant him a decree that was theoretically recognizable in other states. This was a step-by-step process. First, securing a leave of absence. Second, establishing a domicile in Nevada. Third, filing the complaint. And fourth, the final hearing. However, this came with extreme risk. If his wife stayed in their home state and challenged the Nevada decree, a local judge back home might rule the Nevada divorce invalid, leading to a nightmare of divisible divorce, where he was single in Reno but still married in Ohio. The financial burden for men during this era was nearly absolute. The concept of permanent alimony was the standard. In the 1960s, most women were socially and economically discouraged from working outside the home, meaning a man was often legally obligated to maintain his ex-wife's standard of living until she remarried or died. This created what was colloquially known as alimony jail. If a man fell behind on payments due to a job loss or illness, he could be summarily incarcerated. There was no balancing of equities as we see in modern courts. The man was the provider, and his obligation did not end with the dissolution of the household. Furthermore, the tender years doctrine was the prevailing legal philosophy regarding children. This doctrine held that children of a tender age, typically under 13, naturally belonged with the mother. For a father in 1964, seeking primary custody was not just difficult, it was statistically an anomaly. He was often relegated to visitation rights every other weekend, a radical shift from the 24/7 involvement he might have had previously. The psychological landscape was equally treacherous. The 1960s man was raised in the silent generation, or was an older millennial of that era, taught that emotions were to be suppressed in favor of utility and provision. When the structure of the family collapsed, many men lacked the vocabulary to process the transition. There were no men's support groups or online forums. There was only the bar, the office, and the cold reality of a studio apartment. Case studies from psychological journals of the mid-60s highlight a specific type of post-divorce collapse, where men, having lost their role as head of household, struggled with their identity. The help available to them was often limited to stern advice from a lawyer to pay your dues and keep your head down. This masterclass is designed to peel back these layers because the ghost of the 1960s legal system still haunts our modern courts. Many of the aggressive tactics used today by high-stakes attorneys are refined versions of the fault-finding missions of 1962. By looking at the step-by-step evolution of how men moved from being property owners of a marriage to litigants, in a system that viewed them primarily as a bank account, we can better understand the current landscape of domestic law. This series will provide you with the historical data to see the why behind modern statutes, and the how of navigating a world that transitioned from the rigid moralism of the Kennedy era to the complex, multifaceted legalities of today. We are going to explore the exact documents used, the secret strategies of private dicks, and the legislative shifts that finally broke the fault monopoly, ensuring you have a complete high-definition picture of what it meant to fight for your life in the 1960s. To understand the sheer gravity of a 1960s divorce, you have to understand the man in the shadows. He was the private investigator, often a former policeman or a failed insurance adjuster, and in the mid-century legal landscape, he was the most powerful person in a man's life. If you were a man in 1963 attempting to navigate a separation, you weren't just fighting your spouse, you were fighting a surveillance state that you were often paying for yourself, or that was being funded by your wife's family to destroy your reputation. The private investigator's primary goal was to secure proof of fault. Without fault, there was no exit. Imagine if in 2026 every single text message, GPS ping, and grocery store receipt was not just digital data but physical evidence that had to be captured on 35mm film or recorded on bulky reel-to-reel tapes. Historical trends show that the private investigation industry saw a massive surge in domestic cases during this decade. These investigators utilized a specific toolkit designed for the era's limitations. They would use high-powered binoculars from the back of a nondescript sedan parked 3 houses down from your residence. They would wait for hours, documenting who entered the home and at what time. The most sought-after piece of evidence was the photograph of a third party entering a bedroom or the recording of a conversation that implied an extramarital affair. If a man was the one being followed, the potential outcomes were catastrophic. A single grain of evidence suggesting adultery could lead to a total loss of assets and a lifetime of alimony payments that were non-negotiable. Consider the case of a man we will call Robert, a mid-level executive in a 1964 marketing firm. Robert lived in a world where his professional identity was inseparable from his marital status. When his marriage began to deteriorate, he didn't just worry about his home life. He worried about his desk at the office. In the 1960s, many corporate contracts included what were colloquially known as morals clauses. These clauses allowed a company to terminate an employee if their private life brought disrepute to the firm. Divorce, especially a scandalous one involving proven adultery or public cruelty, was seen as the ultimate sign of a man who could not manage his own affairs. If he couldn't manage a household, the logic went, how could he manage a department? Robert's situation highlights the extreme pressure men felt to settle quietly, often giving up 80 to 90% of their net worth just to keep the proceedings out of the local newspapers. In smaller American towns, the local paper would actually publish a list of divorce filings, effectively blacklisting the men involved from social clubs and business partnerships. The legal strategy for a man in this era often involved a concept known as the recrimination defense. This is one of the most bizarre and punishing aspects of 1960s law. In many states, if a wife sued for divorce on the grounds of the husband's adultery, the husband could countersue, claiming the wife was also guilty of a marital fault, such as extreme cruelty or her own infidelity. If the judge found that both parties were at fault, the law of recrimination applied. The doctrine of clean hands dictated that a person could only receive the help of the court if they were innocent. Therefore, if both people were guilty of breaking the marriage contract, the judge would deny the divorce entirely. Imagine the psychological horror of that scenario. Two people who have spent years and thousands of dollars proving they despise each other are told by the state that they must remain legally bound and live together, because neither is virtuous enough to be granted a release. This created a cycle of perpetual litigation and private misery that defined the masculine experience of the era. Step by step, the process of a contested divorce in 1965 was a financial drain that few men were prepared for. First, there was the retainer for a high-powered attorney, which in 1960s dollars could range from $500 to $2,000, a massive sum when the average annual salary was around $6,000. Second, there was the cost of the private investigators who charged by the hour and for equipment. Third, and perhaps most punishing, was the temporary support order. As soon as a divorce was filed, a judge would typically order the man to pay temporary alimony and child support while the case proceeded. Because these cases could drag on for 3 to 5 years, a man might find himself living in a YMCA or a cramped studio apartment, while his entire paycheck was diverted to a home he was no longer allowed to enter. We must also examine the specific legal definitions of cruelty that were used against men. In the early 1960s, cruelty didn't just mean physical violence. It could be defined as mental cruelty, which was a catch-all term used to describe any behavior that made the marriage burdensome. Historical trends in case law from this period show that a man could be accused of mental cruelty for working too many hours, for failing to provide a certain standard of living, or even for having hobbies that took him away from the family unit. Because the definition was so subjective, a man was often at the mercy of the specific judge's personal views on traditional gender roles. If a judge believed a man's primary duty was to be present and silent, and that man was instead ambitious and vocal, he could be found at fault for the breakdown of the union. The impact on the man's relationship with his children during this era cannot be overstated. The tender years doctrine was a nearly insurmountable wall. It was a historical trend based on the assumption that mothers were biologically superior caregivers for children under the age of 13. For a man in the mid-60s, seeking custody was often seen by the court as an act of malice against the mother rather than a genuine desire to parent. Step by step, the father was stripped of his parental authority. He was moved from being a primary protector to a secondary visitor. The standard visitation schedule of the time was often limited to 1 weekend a month and a few hours on a Wednesday evening. This forced transition created a generation of disappearing fathers who weren't absent by choice but were legislated out of their children's daily lives. Imagine if you were told today that you could only see your children 24 days out of the year, and for that privilege you had to pay 60% of your income. That was the mathematical reality for the 1960s divorcee. This financial and emotional bottleneck led to a rise in what were known as underground networks, where men would share tips on how to hide assets or how to find sympathetic judges in different jurisdictions. However, these tactics were incredibly risky and could lead to criminal charges or even higher civil penalties. As we moved deeper into this decade, the pressure cooker of these laws began to crack. The sheer absurdity of the fault-based system was becoming a public laughingstock, as more and more staged adulteries were laughed out of court or exposed as frauds. Men began to organize, albeit in small, quiet ways, questioning why the law treated them as nothing more than a walking bank account with no right to emotional fulfillment or a fresh start. But before the no-fault revolution could take hold, there was one final high-stakes option for the man who was truly desperate. It was an option that involved international travel, high-speed desert drives, and a complete gamble on the legality of foreign borders. In the next part, we are going to dive into the world of the Reno ranches and the Mexican divorce mills. We will look at how men risked everything, their citizenship, their jobs, and their remaining savings, to flee the jurisdiction of their home states. We will uncover the secret maps used by men to find the fastest way to a decree of divorce, and the legal trapdoors that waited for them when they returned home thinking they were free, only to find the police waiting at the airport. The escape hatch was open, but the cost of entry was higher than anyone predicted. To understand the 1960s escape hatch, you have to look at the map of the United States through the eyes of a man who was legally trapped. If you were living in a state like New York or South Carolina during the mid-60s, the law was a cage. In New York, the only legal ground for divorce was adultery, a standard so high and so socially damaging that many men felt their only option was to flee the jurisdiction entirely. This gave rise to the migratory divorce, a high-stakes legal maneuver that sent thousands of men across state lines and international borders in search of a fresh start. The most famous destination was Reno, Nevada, known worldwide as the divorce capital of the world. But for the man of 1966, Reno was not a vacation. It was a grueling, expensive, and legally precarious 6-week residency that tested his finances and his professional standing. The Reno Cure, as it was colloquially known, required a man to establish a bona fide domicile in the state of Nevada for exactly 6 weeks. Historical trends show that this created a massive industry of divorce ranches. These were not luxury resorts. They were working ranches or boarding houses where men from all over the country lived in a strange, temporary brotherhood of the broken-hearted. Imagine a group of engineers, lawyers, and salesmen, all having left their lives on the East Coast, sitting on a porch in the Nevada desert, counting down the 42 days required by law. The step-by-step process was rigid. First, you had to physically move to Nevada. Second, you had to find a job or show intent to stay to satisfy the residency requirement. Third, you had to be seen in public, often at local bars or stores, so that witnesses could later testify in court that you were indeed a resident. Finally, on day 43, your lawyer would file the papers, and a sympathetic Nevada judge would grant a decree based on extreme mental cruelty, a ground that was almost never accepted in the man's home state. The cost was astronomical for the average worker. A stay at a reputable divorce ranch in 1967 could cost anywhere from $50 to $100 a week, plus legal fees that easily exceeded $1,000. When you factor in the loss of 6 weeks of wages and the cost of travel, the potential outcomes were often a total depletion of a man's life savings. Case studies from the era show that many men took out secret bank loans or sold their personal vehicles just to afford the trip. They were gambling their entire financial future on the hope that when they returned home, their home state would recognize the Nevada decree. This was a massive legal gamble. Under the full faith and credit clause of the U.S. Constitution, states are generally required to respect the judicial proceedings of other states. However, many conservative judges in states like New York found a loophole. They argued that the man never truly intended to become a Nevada resident, and that the 6-week stay was a fraud. This led to the nightmare scenario of the divisible divorce. A man would return from Reno, believing he was a bachelor, only to find that his home state viewed him as still married. If he attempted to remarry, he could be charged with bigamy. If he stopped paying his wife because he thought the Nevada decree ended his obligation, he could be arrested for non-support. The legal system was effectively a patchwork of conflicting rules where a man's marital status changed as soon as he crossed a state line. Imagine if in 2026 your digital identity and legal status completely reset every time you drove over a bridge, leaving you vulnerable to criminal prosecution for actions that were legal 10 miles away. That was the reality for the migratory divorcee. For those who couldn't afford 6 weeks in Nevada or who needed a faster exit, there was the Mexican divorce mill. Located primarily in Ciudad Juarez, just across the border from El Paso, Texas, these mills offered a divorce in as little as 24 hours. There was no residency requirement. You simply had to show up, sign a book, and pay a fee. For a man in 1968, the Mexican option was the ultimate quickie divorce. He could fly into El Paso in the morning, cross the bridge, have a decree by lunch, and be back at his desk in Chicago by the following Monday. Historical trends indicate that at the height of the decade, Juarez was processing over 20,000 divorces a year for Americans. However, the Mexican divorce was the most legally fragile document on earth. Because it was an international decree, U.S. states were not constitutionally required to recognize it. It was a matter of comity or mutual respect, and many American courts had zero respect for the Juarez system. Case studies reveal thousands of men who were left in a legal no man's land. Consider the case of James, a 1967 aerospace engineer. James flew to Mexico, got his decree, and 6 months later married a new woman in California. 2 years later, his first wife filed for divorce in New York, claiming the Mexican decree was a sham. The New York court agreed. James was suddenly legally married to 2 different women in 2 different states. He was ordered to pay alimony to the first wife while his second marriage was declared void, meaning his new children were legally considered illegitimate and he had no rights to his new home. This type of legal collapse was a constant threat, hanging over the head of every man who tried to bypass the system. The social pressure on these men was equally intense. In the 1960s, a man who went to Reno or Mexico was often seen as a deserter. The corporate world viewed these migratory divorces with extreme suspicion. If a man's HR department found out he had taken a 6-week leave of absence, that was actually a stint at a Nevada ranch, his chances for promotion often evaporated. He was seen as someone who was cutting corners, someone who lacked the moral fortitude to tough it out in a difficult marriage. The step-by-step destruction of a man's reputation was a common side effect of the search for freedom. He would lose his standing in the church, his membership in the local Lions Club, and often the respect of his own parents, who had lived through the Depression and viewed divorce as a luxury for the weak. As the decade drew to a close, the sheer volume of these migratory divorces began to force a change in the American legal consciousness. The system was broken and everyone knew it. Men were fleeing their homes, committing perjury in Nevada courts, and spending their life savings on international decrees that weren't worth the paper they were printed on. The pressure was building for a radical shift in how the law viewed the end of a marriage. Men were no longer willing to be treated as criminals for wanting to leave a toxic situation. They were tired of the private dicks, the Reno ranches, and the Mexican mills. They wanted a legal path that didn't involve fraud or flight. But as the movement for legal reform began to pick up steam, a new and even more complex set of problems began to emerge. The transition from the fault-based system to the no-fault era was not going to be the clean break many men hoped for. In fact, it was about to trigger a massive shift in how assets, custody, and the very definition of fatherhood were handled in the American court system. In the next part, we are going to look at the birth of no-fault divorce in 1969 California, and how the man who signed it into law, Ronald Reagan, would later call it one of his greatest mistakes. We will explore how the end of the villain and victim narrative in court actually made the financial battle for men even more aggressive and unpredictable. We are entering the era of the modern divorce war, and the rules of engagement were about to be rewritten in a way that would change the American family forever. The signing of the California Family Law Act of 1969 by Governor Ronald Reagan was a seismic shift that effectively detonated the traditional legal architecture of American domestic life. For the man of 1969, the world he woke up in on December 31st was governed by the rules of fault, where he was either a villain to be punished or a victim to be compensated. But by January 1, 1970, when the law took effect, the entire moral compass of the courtroom was discarded. This was the birth of no-fault divorce, and while it was marketed as a humane way to end the charade of staged adulteries and private investigators, the potential outcomes for men were far more complex and often more punishing than the system it replaced. Historical trends indicate that this single piece of legislation in California acted as a domino, triggering a nationwide movement that would see almost every state adopt some form of no-fault statutes over the next 2 decades. Imagine if in 2026, the federal government suddenly announced that every long-term employment contract, every business partnership, and every mortgage could be unilaterally terminated by one party without any proof of wrongdoing. Yet the other party would still be legally required to provide ongoing financial support based on the previous terms of the agreement. This was the shock to the system felt by the American breadwinner at the turn of the decade. Before this shift, a man who had been a faithful provider and a loyal husband had a certain level of legal protection. If his wife wanted a divorce but had no grounds of fault against him, he held the bargaining chips. He could refuse the divorce unless the settlement terms were reasonable. He had what was known as the power of the veto. The 1969 Act stripped that power away instantly. Step by step, the courtroom experience for a man changed from a trial of facts to a clerical process of liquidation. Under the old system, a man's attorney would spend months building a defense or a countersuit. They would gather evidence to show that the man was the aggrieved party. In the new no-fault era, the court no longer cared who did what to whom. The only requirement was to state that the marriage had suffered an irremediable breakdown. For the man who didn't want the divorce, there was no defense. You could not argue that the marriage was fine. You could not argue that you were a good person. The court simply took the word of the filing party and proceeded to the next phase, the division of the spoils. Ronald Reagan, who was the only U.S. president to have been divorced at that time, signed this bill believing it would reduce the acrimony and the perjury that had become standard in California courts. However, in his later years, He would describe this as one of the greatest mistakes of his political career. The reason for this regret lies in the unintended consequences of the law's financial mandates. The 1969 Act introduced the concept of community property division in a much more rigid way. In a fault-based system, if a wife was found to be the one at fault, the husband might retain a larger share of the assets as a form of judicial equity. Under no fault, the assets were split 50-50 regardless of conduct. For a man who had spent 20 years building a business, funding a pension, and paying off a mortgage while his wife had not worked outside the home, this felt like a government-sanctioned heist. Consider the case study of a man we will call Thomas, a high-level civil engineer in Los Angeles in 1970. Thomas had followed every rule of the 1950s and 60s social contract. He worked 60 hours a week, provided a suburban home, and had a clean record. When his wife filed for divorce under the new no-fault law, Thomas found that his 20 years of good behavior were legally irrelevant. The court ordered the immediate sale of the family home to satisfy the 50-50 split. Because his pension was considered community property, half of his future retirement security was signed away in a single hearing. Thomas, who had never missed a mortgage payment, was suddenly living in a one-bedroom apartment, watching his life's work being liquidated by a system that refused to acknowledge his loyalty to the marriage contract. The shift also fundamentally altered the nature of alimony, or what we now call spousal support. In the pre-1970 era, alimony was often seen as a penalty for the guilty party. If a man was the innocent party, he rarely had to pay it. But with the removal of fault, alimony became a math equation based on the length of the marriage and the disparity in income. Because the 1960s culture had largely prevented women from entering high-earning career paths, the math almost always pointed toward the man paying significant portions of his income for a rehabilitative period that could last for years or even a lifetime. This created a new class of newly poor professional men who were earning high salaries but living on the margins because of their support obligations. Historical trends show that the divorce rate in California doubled within the first few years of the no-fault law. This was not necessarily because people were unhappier, but because the cost of leaving had been lowered for the party who stood to gain from the 50-50 split, and the barrier of proving fault had been removed. For men, this meant that the stability of their home and their financial future was now subject to the unilateral whim of their partner. The psychological impact was profound. The 1960s man who valued stability and keeping up appearances was now living in a world where the floor could fall out from under him at any moment, and the law would offer him no shield. Furthermore, the no-fault revolution didn't just affect the money. It changed the battle for children. In the previous era, if a mother was found to be at fault, for example, if she was caught in an affair, the father had a much stronger case for custody. With the removal of fault, the conduct of the parent was no longer a primary factor unless it was directly harmful to the child. The tender years doctrine, which we discussed in previous parts, remained the default setting for most judges. This meant that while men were now losing half of their assets in a no-fault split, they were still fighting a fault-based uphill battle for their children. They were losing the bargaining chip of the assets while gaining no ground in the nursery. The 1969 California Family Law Act was the beginning of the Me decade, where individual fulfillment began to take precedence over the preservation of the family unit. Men were forced to adapt to a legal landscape where they were no longer heads of households, in the eyes of the court, but partners in a terminable at-will contract. This shift required a complete reimagining of financial planning and personal security. Men began to realize that the old advice of just be a good provider was no longer enough to protect them from a total loss of status and wealth. As we analyze this transition, it becomes clear that the help available to men in the late 1960s was quickly becoming obsolete. The old strategies of hiring private eyes to catch a cheating spouse were being replaced by a need for sophisticated forensic accountants. The battle shifted from the bedroom to the ledger. Men had to learn a new language of valuation, deferred compensation, and future interest. The stakes had never been higher, and the rules were being written as the cases were being tried. But even as the legal system moved toward this cold mathematical 50-50 split, the human element refused to be ignored. The removal of fault from the legal papers didn't remove fault from the human heart. If a man couldn't fight for his dignity in the divorce court, he would find other, more aggressive ways to protect what was his. The 1970s were about to usher in the era of the high-stakes custody war, where children became the ultimate and only remaining leverage in a system that had commodified everything else. In the next part, We are going to look at the hidden war for custody that erupted in the wake of the no-fault revolution. We will explore the rise of parental alienation as a tactic in the early 70s and how men began to fight back against the tender years doctrine using the newly emerging field of child psychology. The era of the weekend dad was beginning, but some men were refusing to go quietly into the shadows. We will look at the radical strategies used by fathers to maintain a presence in their children's lives when the law was designed to push them out. To understand the fight for fatherhood in the early 1970s, you have to look at the legal fossil that was the tender years doctrine. This was a judicial presumption that had its roots in the Victorian era, holding that mothers were biologically and spiritually superior caregivers for children during their formative years, usually defined as birth through age 13. For a man in 1971, walking into a custody hearing was like walking into a game where the referee had already decided the winner before the coin toss. Historical trends show that in the late 1960s and early 1970s, mothers were awarded primary custody in approximately 90% of contested cases. For the remaining 10% of men who succeeded, it wasn't usually because they were seen as better parents, but because they had successfully proven the mother was morally unfit, a high legal bar that often involved proving active addiction or extreme neglect. Imagine if in 2026, a court told you that despite having no criminal record, a stable job, and a deep emotional bond with your children, you were legally considered an auxiliary parent whose only function was to provide a check and see your kids for 4 days a month. This was the crushing reality for the American father. But as the 1970s began, a small, determined group of men started to push back, utilizing the emerging field of child psychology to challenge the very foundations of the tender years doctrine. They moved the conversation from parental rights to a new legal standard: the best interests of the child. Step by step, the strategy for the 1970s father changed. The first step was the professionalization of his parenting. Because the court assumed he didn't know how to raise a child, a man had to overcompensate. He couldn't just have a spare bedroom. He had to have a meticulously curated environment that mimicked a nuclear family home. Case studies from 1972 show men who would deliberately move their own mothers or sisters into their new bachelor apartments to prove to a judge that a female influence was present, effectively leveraging the court's own gender biases to secure more time with their children. This was known as the live-in relative strategy, and for many men, it was the only way to bypass the judge's skepticism of a single father's capability. The second step involved the introduction of expert witnesses. In the mid-1960s, psychologists were rarely seen in divorce courts. By 1973, they were becoming the most important people in the room. Men began hiring child development experts to testify that a father's role was not just economic but essential for the psychological development of both sons and daughters. These experts pointed to historical trends in developmental data, showing that children with involved fathers had higher academic achievement and lower rates of behavioral issues. This was a radical argument at the time. It shifted the focus from the mother's biological sanctity to the child's developmental needs. Consider the case of a man we will call David, a 1972 insurance adjuster. When his marriage ended under the new no-fault laws, David refused to accept the standard every other weekend visitation. He did something few men had done. He requested a court-ordered home study. He paid for a social worker to come to his house and observe him with his children. He documented every doctor's appointment he attended, every school play, and every meal he prepared. In court, his lawyer used this mountain of evidence to argue that the tender years doctrine was a violation of the Equal Protection Clause of the Constitution. While he didn't get full custody, he was one of the first in his jurisdiction to be granted a 60-40th split, a potential outcome that was unheard of just 5 years earlier. However, as men gained ground using these psychological tools, the opposition developed its own set of high-stakes tactics. This period saw the early emergence of what some psychologists began to identify as parental alienation, though it didn't have that formal name yet. Mothers who feared losing custody, or who were deeply embittered by the divorce, began to use their primary access to the children to systematically erode the father's reputation. A man would arrive for his scheduled Wednesday evening visit only to find the house dark and no one home. Or the children would be told that their father didn't love them anymore, and that the child support money was the only reason they had food. The legal system was ill-equipped to handle this. If a man complained to a judge that his visitation was being blocked, the judge would often give the mother a light warning and tell the father to be more patient. The enforcement of visitation rights was practically non-existent. Historical trends in the 1970s show a massive spike in men who simply gave up, not out of a lack of love, but because the emotional and financial cost of fighting a custodial parent who was intent on blocking access was unsustainable. They became the disappearing fathers that social critics would later lament, but the data suggests many were actually pushed-out fathers, who were defeated by a system that refused to enforce its own orders. For the men who did stay and fight, the financial cost was the third major hurdle. Fighting for custody in 1974 could easily cost $5,000 to $10,000 in legal and expert fees. In 1970s currency, this was the equivalent of a man's entire annual salary. This created a two-tiered system of justice. If you were a wealthy professional, you could afford the psychologists and the high-powered attorneys to fight the tender years doctrine. If you were a blue-collar worker, you were effectively priced out of your children's lives. The potential outcomes were dictated as much by the man's bank balance as by his parenting ability. This financial pressure led to the rise of early fathers' rights organizations. Men began to realize that their individual battles were part of a systemic bias. They started meeting in church basements and community centers, sharing names of sympathetic judges and aggressive lawyers. They began to lobby state legislatures to replace the tender years doctrine with a gender-neutral, best interest statute. This was the beginning of the slow move toward joint custody, which wouldn't become a standard legal option in many states until the late 1970s and early 1980s. The 1970s father was a pioneer in a very dark forest. He was the first generation of American men to insist that being a provider was not the sum total of his identity. He was fighting for the right to be a nurturer in a culture that viewed that as a female-only trait. This struggle was messy, expensive, and often failed, but it laid the groundwork for the modern shared parenting movement we see in 2026. Every time a father today is granted 50-50 custody without having to prove his ex-wife is an alcoholic, he is standing on the shoulders of the men from 1973 who were mocked by judges for wanting to change a diaper or take a child to the pediatrician. But even as these men fought for their children, a darker trend was beginning to emerge in the courtrooms. As the legal barriers to divorce fell and the battle for custody intensified, a new and devastating weapon was introduced into the domestic arena. It was a weapon that could end a man's custody case, his career, and his freedom in a single afternoon. It was the rise of the silver bullet of the 1970s legal world, the tactical false accusation. In the next part, we are going to dive into the explosion of domestic violence and abuse allegations that coincided with the fight for joint custody. We will look at how the legal system responded to these claims, the lack of due process for the accused, and how a single filed report could result in a man being barred from his home and his children for months without a single shred of physical evidence. The war was no longer just about money or time. It was about the very survival of a man's name. The silver bullet was not a physical projectile. It was a legal maneuver that could paralyze a man's life with a single signature from a magistrate. In the mid to late 1960s, as the battlegrounds of divorce shifted from proving adultery to securing the family home and the children, the tactical use of domestic allegations became a standard, albeit dark, tool in the litigator's arsenal. Historical trends indicate that as the stakes of custody increased, the frequency of these 11th-hour accusations surged. For the man of 1968, this was the ultimate ambush. One day he was a respected member of the community, an engineer or a manager with a clean record and a steady hand. The next, he was served with an ex parte order that effectively stripped him of his home, his children, and his reputation before he even knew a case had been filed. The mechanism was deceptively simple. Imagine if in 2026, an individual could go to a web portal, file a statement without providing a single photo, medical record, or witness, and within 2 hours, have the police arrive at your office to escort you off the premises. In the 1960s, this was done via a temporary restraining order or a writ of assistance. Because the legal system prioritized the immediate safety of the household based solely on the affidavit of the filing party, the accused man was given no opportunity to defend himself in the initial stage. This was the shoot first, ask questions later era of domestic law. The step-by-step process of the silver bullet often began on a Friday afternoon. This was a calculated move by aggressive attorneys. By filing on a Friday, the man would be served at his place of business, maximizing the social shame, and then he would be unable to reach a judge or a lawyer until Monday morning. He was forced to spend the weekend in a motel or on a friend's couch, barred from his own property, while his wife and her legal team solidified their control over the domestic environment. Case studies from 1969 show the devastating impact this had on professional men. Take the character of Mark, a senior project lead at a growing aerospace firm. Mark had spent 15 years building a career that relied heavily on a top-secret security clearance. When his wife's attorney filed a tactical allegation of mental cruelty and physical threat to gain exclusive possession of their suburban home, Mark was served in front of his colleagues. The historical trend in the corporate sector at that time was one of extreme risk aversion. The mere existence of a police-served order was enough for Mark's company to place him on administrative leave. His clearance was flagged, and his career trajectory was effectively terminated. The potential outcomes for men in Mark's position were almost always negative. Even if the allegations were later found to be unsubstantiated, the stain on the professional record was permanent. In the 1960s, a man's character was his currency, and the silver bullet was designed to devalue that currency to zero. The step-by-step escalation often involved the removal of personal property. While a man was barred from the home, historical trends show that the filing party would often use that time to purge the house of any evidence that favored the husband. Journals, financial records, and even sentimental items were often moved or destroyed. By the time the man was finally granted a hearing, which could take weeks or even months, the status quo of the household had been completely reset. The court would look at the current situation. The mother was in the home, the children were settled, and the father was living in a transient state. Judges, leaning on the social norms of the era, were loath to disrupt the children again. Thus, the temporary emergency order frequently became the permanent template for the final divorce decree. The psychological warfare behind these tactics was profound. Men were often told by their own lawyers that the best defense was a preemptive strike. This led to a toxic legal environment where both parties were encouraged to race to the courthouse to file the first allegation. If a man suspected his wife was planning to leave, he was sometimes advised to file for divorce first and move the assets into a separate account. However, this was a high-risk strategy that often backfired in the 1960s, as judges viewed a man's financial maneuvering as a sign of bad faith and cruelty. The potential outcomes for a man who tried to play the game by the same dirty rules were often harsher than if he had simply waited, as the court expected a higher standard of gentlemanly conduct from the male party. Furthermore, the lack of due process in the mid-century legal system meant that a man could be kept away from his children for an indefinite period. Imagine the emotional toll on a father who, for 10 years, had tucked his children into bed every night, only to be told by a uniformed officer that he could not come within 500 feet of them. There were no cell phones, no video calls, and no way to explain the situation to the children without violating the court order. Historical trends show that this forced separation was often used as a tool of parental alienation. By the time the man saw his children again, they had been told a narrative of his dangerousness or abandonment. This was the step-by-step destruction of the father-child bond, facilitated by a legal system that favored administrative speed over evidentiary truth. Data from various state bar journals in the late 1960s suggests that the rise of these tactical orders coincided with a shift in the legal profession toward a more adversarial model of family law. Previously, many family lawyers acted as mediators or counselors at law. By 1969, a new breed of bomber attorneys had emerged, specializing in high-conflict cases where the goal was total victory, rather than a fair settlement. For the man of this era, the help he needed was no longer a sympathetic ear, but a legal strategist who understood how to counter the silver bullet. This often meant hiring private investigators of his own to prove his whereabouts at the time of the alleged incidents, or gathering testimony from neighbors and co-workers to reconstruct his reputation piece by piece. The cost of defending against a silver bullet was another layer of the financial trap, because the man was often paying for his wife's legal fees as well as his own. Under the standard support laws of the time, he was essentially funding the very machine that was being used to destroy him. He had to pay for the investigation, the multiple hearings to vacate the temporary order, and the forensic accountants needed to protect his remaining assets. Historical trends indicate that a contested silver bullet case could easily double or triple the cost of a standard divorce, often leaving the man with nothing but his clothes and a mountain of debt by the time the final gavel fell. As we move into the end of the 1960s, the law and order culture of the United States began to clash with the reality of these domestic battles. People were starting to see the cracks in a system that allowed for such radical shifts in a person's life based on unverified claims. But the shift toward a fairer system was slow, and many men were lost in the transition. They were the casualties of a legal revolution that sought to protect the vulnerable, but often ended up weaponizing the law against the innocent. But what happened when the man finally made it to the other side? What happened when the decree was signed, the home was sold, and he was left standing in the wreckage of his former life? The 1960s had one final hurdle for the divorced man, a social and professional re-entry process that was almost as difficult as the divorce itself. In a world that only had room for family men, the bachelor by force was a man without a country. In the next part, we are going to explore the social exile of the divorced man in 1960s America. We will look at the hidden blacklists in corporate HR departments, the singles complexes that began to pop up in cities like Dallas and Atlanta, and the psychological impact of being a non-person in a society obsessed with the nuclear family. We will dive into how men began to rebuild their lives from zero, and the secret social networks they formed to survive a culture that wanted them to disappear. The moment the final decree was signed in 1968, a man didn't just lose a wife, he often lost his entire social and professional infrastructure. In the mid-century American landscape, the nuclear family was the only valid currency for adult participation in the community. When that family unit dissolved, the man was essentially unplugged from the grid. Imagine if in 2026, your social media accounts were deleted, your professional networking profile was flagged as unstable, and your neighbors physically turned their backs on you when you walked to your mailbox. This was the silent exile of the divorced man. He was no longer a husband, he was rarely a primary father, and in the eyes of his employer he was a liability. Historical trends from the late 1960s show a phenomenon known as the stability index in corporate HR departments. At major firms like Chrysler or General Electric, a man's marital status was a key metric in his performance reviews. A married man with 3 children was seen as anchored, disciplined, and predictable. He had a mortgage to pay and a family to provide for, which made him a low-risk, high-loyalty employee. A divorced man, however, was viewed as a flight risk. There was a prevailing cultural suspicion that if a man couldn't manage his own household, he certainly couldn't be trusted with a department budget or a team of subordinates. Case studies of middle management layoffs during this era frequently show that divorced men were often the first to be let go during restructuring, justified by the vague terminology of personality conflicts or lack of fit. Consider the case of a man we will call Stephen, a senior account manager for a high-profile advertising agency in 1967. Before his divorce, Stephen's career was on a vertical trajectory. He and his wife hosted the quarterly cocktail parties that were essential for client retention. But the moment his divorce became public knowledge, the invitations stopped. He was no longer part of the couple's circuit. More importantly, his boss began to bypass him for projects that required long-term travel or high-stakes negotiations. The assumption was that Stephen was too emotionally volatile, or that his personal life would distract from his professional duties. This was a step-by-step dismantling of his career. First, the lateral move to a less important account. Second, the omission from the annual executive retreat. Third, the subtle suggestion that he might be happier at a smaller firm with less pressure. For the 1960s man, the loss of his marriage often predated the loss of his livelihood by less than 18 months. The residential transition was the next stage of this descent. In 1968, American suburbs were not designed for single men. There were no bachelor pads in the cul-de-sacs of Levittown. A man who was forced out of his family home had to move into what were known as singles complexes. These were the first generation of high-density apartment buildings, designed specifically for the newly uncoupled. While the popular culture of the time, fueled by magazines like Playboy, tried to paint these as dens of hedonistic freedom, the reality was much grimmer. They were often transitional spaces filled with men who didn't know how to cook a meal, how to operate a washing machine, or how to inhabit a space that didn't revolve around a family schedule. Imagine the psychological shift of moving from a 4-bedroom house with a manicured lawn to a 500-square-foot studio with a kitchenette. Step by step, the man's identity was eroded. He lost his workshop in the garage. He lost his library. He lost the daily noise of his children. The historical trend in these apartment complexes was one of profound isolation. Men would gather in the communal laundry rooms or at the complex pool, forming a strange, quiet brotherhood of the displaced. They were the invisible men of the Great Society, living in the shadows of the very suburbs they had helped build. Financially, the rebuild was almost impossible. In 1967, the average salary for a professional man was approximately $8,000 a year. Under the permanent alimony and child support laws of the time, it was common for a judge to award 60 to 70% of that income to the ex-wife. This was based on the social assumption that the woman could not and should not work, while the man could simply work harder to bridge the gap. After paying his support obligations and the rent on his modest apartment, a man might be left with less than $50 a month for all other expenses. This created a new class of professional paupers, men who wore expensive suits to the office but lived on canned soup and crackers in private. The potential outcomes for a man in this financial vice were often desperate. Some men took on second or third jobs, working as night security guards or driving delivery trucks, just to stay ahead of the alimony jail that loomed over every missed payment. Others were forced to move back in with their elderly parents, a move that was seen as the ultimate admission of failure in a culture that prized masculine independence. There was no bankruptcy protection for support obligations, and there were no social safety nets for the divorced male. He was expected to be an infinite well of provision, regardless of his actual resources. Socially, the ostracization was total. The 1960s social life was built entirely around the couple. If you were a single man, you were a threat to the stability of other marriages. Neighbors who had been friends for a decade would suddenly stop calling. If a man tried to maintain his old social ties, he would find himself as the fifth wheel at every dinner, a living reminder of the fragility of the suburban dream. This led to the rise of secret social networks. Men would congregate in specific bars or fraternal organizations like the Elks or the Masons, not for the rituals, but for the company of other men who understood the cost of the divorce machine. These were the only places where a man could speak openly about his loss without being judged for his failure to keep his house in order. We also have to look at the impact of the draft and the ongoing conflict in Vietnam. For younger divorced men in the late 1960s, the loss of their marital status meant the loss of their 3A dependency deferment. A man who was married with children was often shielded from the draft. The moment that marriage dissolved, he was reclassified as 1A. Historical trends show a spike in divorce-age men being inducted into the armed forces, effectively sending them from the domestic battlefield of the courtroom directly to the jungles of Southeast Asia. This was the ultimate silver bullet used by some attorneys, filing for divorce specifically to trigger a man's eligibility for the draft, thereby removing him from the custody equation entirely. The 1960s man was caught in a pincer movement between a legal system that viewed him as a wallet and a social system that viewed him as a pariah. He had to learn to navigate a world that had no place for him. He had to learn how to be a father from a distance, how to be a professional without a pedigree, and how to be a man without a home. It was during this period of extreme isolation that the first seeds of the modern men's movement were planted. Men began to realize that the traditional social contract was a one-way street, and they started to ask the questions that would eventually lead to the radical legal shifts of the 1970s. But as these men struggled to rebuild, they noticed something peculiar. The legal system was beginning to evolve, but not in the way they expected. The end of the 1960s brought a new kind of legal professional into the arena: the forensic psychologist. Suddenly, the battle wasn't just about money or morals. It was about the very sanity of the participants. The courtroom was about to become a laboratory, and the men of the era were the primary test subjects. In the next part, we are going to look at the rise of the psychological evaluation in 1970s divorce cases. We will explore how fitness became a weaponized term, how Rorschach tests and personality inventories were used to decide who got to see their children, and the terrifying power of the court-appointed shrink. The war for the home was over. The war for the mind was just beginning. As the 1970s dawned, the legal battlefield for the American man shifted from the physical surveillance of the private investigator to the internal landscape of the human mind. The war for the home was over. The war for the mind was just beginning. This was the era of the psychological evaluation, a period where a man's fitness as a father was no longer determined by his ability to provide a paycheck, but by his performance on a series of abstract and often biased clinical tests. For a man in 1971, the court-appointed psychologist became the most terrifying figure in the divorce process, possessing the power to sever a parental bond based on a 3-hour interview and a stack of ink blots. Imagine if in 2026, you were required to sit in a sterile room and answer 566 true or false questions, knowing that if you answered too many of them in a way that suggested frustration or anger, you would lose the right to see your children for the next 5 years. This was the reality of the Minnesota Multiphasic Personality Inventory, or the MMPI, which became a standard tool in high-conflict custody cases. The potential outcomes for men were often skewed by the very nature of the test. Historical trends show that men going through a contested divorce are naturally under extreme stress, often exhibiting signs of depression, anxiety, or justifiable anger. However, the MMPI was designed to identify chronic pathology, not situational stress. A man who was simply devastated by the loss of his family could easily score high on Scale 4, known as the Psychopathic Deviate Scale, which measured social alienation and resistance to authority. In the hands of an aggressive opposing counsel, a high score on Scale 4 was presented not as a reaction to a traumatic life event, but as proof of a fundamental character flaw that made the man a danger to his children. Step by step, the psychological evaluation process was a gauntlet of vulnerability. The first step was the clinical interview. A man would sit across from a stranger who was often biased toward the traditional tender years doctrine, and he was expected to perform a delicate balancing act. If he showed too much emotion about the divorce, he was labeled as emotionally unstable. If he showed too little, he was described as cold, detached, or lacking in parental warmth. There was no middle ground for the mid-century masculine archetype. Case studies from 1972 show that men were frequently penalized for displaying what psychologists called hostile aggressive traits, even if that aggression was a direct response to having their bank accounts frozen or their home access denied. The second step involved the use of projective testing, most notably the Rorschach ink blot test. In the early 1970s, the Rorschach was used with a degree of clinical certainty that would be considered scientifically suspect today. A psychologist would show a man a series of 10 symmetrical ink blots and ask him what he saw. If a man, perhaps an engineer or a veteran, saw structural elements or combat-related imagery, the report might suggest he possessed a rigid, militaristic personality that was unsuitable for nurturing young children. There was no standardized scoring system like the one we have today. It was entirely subjective, based on the specific school of thought the psychologist followed. A man's entire future could hinge on whether he saw a butterfly or a predator in a smudge of black ink. The third step was the gathering of collateral contacts. The psychologist would interview neighbors, teachers, and even the man's employer. In the tightly knit social circles of 1970s America, this was a form of professional and social suicide. To have a court-appointed shrink calling your boss to ask about your mental stability was often the final nail in a man's career coffin. Historical trends show that many men would settle for unfavorable custody terms simply to stop the psychologist from making these phone calls. The mere threat of a fitness evaluation was often enough to force a man into a total financial surrender. Consider the case of a man we will call John, a 1971 middle manager at a chemical plant. John was a dedicated father who coached his son's little league team and never missed a school play. When his wife's attorney requested a psychological evaluation, alleging that John had an explosive temper, the court agreed. John had to pay for the evaluation himself, a cost that in 1970 dollars exceeded $1,500. During the MMPI, John answered honestly that he felt people were out to get him. A rational feeling given that his wife's lawyer was actively trying to destroy his life. The psychologist interpreted this as paranoia. In the final report, John was described as having a passive-aggressive personality with underlying narcissistic traits. Because of this single document, the judge, who had no psychological training, restricted John to supervised visitation for 6 months. John's son was told his father was sick and needed to get better before they could play ball again. This was the psychological silver bullet in action. The bias inherent in mid-century psychology cannot be ignored. At this time, the field of psychology was still heavily influenced by the idea that a man's primary contribution to the family was instrumental, providing resources, while the woman's was expressive, providing emotional support. If a man tried to argue that he was the more nurturing parent, he was often viewed through a lens of suspicion. Psychologists would look for signs of overcompensation or a hidden agenda. The step-by-step destruction of the father's role was often justified by clinical language that sounded objective, but was rooted in deeply held gender stereotypes. Furthermore, the rise of the psychological expert created a new layer of the divorce industry. These experts were expensive, and they often worked repeatedly with the same law firms. This created a potential for a feedback loop where a psychologist knew exactly what kind of report a specific attorney was looking for to win a case. For the man of 1973, it wasn't just about being a good father. It was about being able to afford a counter-expert who could debunk the first expert's findings. This led to a war of the shrinks, where the child's well-being was often lost in a sea of competing clinical jargon and $600 an hour testimonies. This era also saw the first attempts to pathologize the father's desire to remain involved. If a man fought too hard for joint custody, which was still a radical and largely unrecognized concept, He was often labeled as obsessive or controlling. The legal system preferred the clean break, and a man who refused to disappear into the role of a weekend visitor was seen as a disruption to the new post-divorce order. Historical trends show that men were frequently advised by their own counsel to play the role of the humble, defeated father in psychological interviews, as any sign of fight was interpreted as a lack of cooperation with the mother's household. As we move toward the mid-1970s, the failure of these psychological tools to provide truly fair outcomes began to frustrate both the courts and the public. The realization was setting in that you couldn't solve a human tragedy with a personality test. But as the psychological war reached its peak, a new and even more complex front was opening up. The transition to a more modern economy meant that a man's wealth was no longer just in his house or his car. It was hidden in pensions, stock options, and deferred compensation. In the next part, we are going to look at the rise of the forensic accountant and the high-stakes world of asset hiding in 1970s divorce. We will explore the secret methods men used to protect their life's work from the 50-50 split, the legal trapdoors of the early IRS audits, and how the battle for the children was suddenly eclipsed by the battle for the offshore account. The era of the emotional divorce was being replaced by the era of the white-collar divorce war. The shift from the bedroom to the ledger was not merely a change in tactics. It was a fundamental reorganization of how a man's worth was calculated by the state. By the mid-1970s, the forensic accountant had officially replaced the private investigator as the most dangerous person in the courtroom. If you were a man in 1974, your primary fear wasn't a grainy photograph of a mistress, it was a lifestyle audit. The legal system had moved into a phase where the math was the morality. Historical trends indicate that as states followed California's lead into no-fault territory, the fight for assets became a white-collar war of attrition. Imagine if in 2026 the government maintained a ledger of every intellectual spark you had, every professional connection you made, and every hour of overtime you logged, only to tell you that half of that intangible value belonged to someone else upon the dissolution of a contract. In the 1970s, this was the birth of the valuation of professional goodwill. For the self-employed man, the doctor, the lawyer, the small business owner, this was a catastrophic development. The court began to argue that a man's reputation and his future earning capacity were marital assets that could be appraised and divided. This wasn't just about splitting the bank account. It was about placing a lien on his future. Step by step, the forensic audit of a man's life became a standard procedure. First, the accountant would perform a 5-year look back at all personal and business records. They weren't just looking for hidden accounts. They were looking for personal expenses run through the business. In the 1960s, it was common for a man to pay for his car, his meals, and even his family vacations through his company's ledger. While this was standard practice at the time in a 1974 divorce, these were rebranded as perquisites or perks, which were added back into his total income to inflate the alimony and child support requirements. The man who thought he was earning $10,000 a year suddenly found a court declaring his real income was $15,000 based on his lifestyle, leaving him with support obligations that exceeded his actual take-home pay. Consider the case study of a man we will call George, a 1975 owner of a mid-sized construction firm. George had spent 20 years building his company from a single truck to a fleet of 30. When his marriage ended, the court didn't just look at the equipment and the cash on hand. They hired an expert to determine the value of George's name in the community. They called this personal goodwill. The potential outcomes for George were devastating. He was ordered to pay his ex-wife half of the value of a business that he still had to run, effectively forcing him to take out a massive high-interest loan against his own company to buy out her interest. He was paying for his own success twice, once to build it and once to keep it. This period also saw the rise of the pension battle. Before the Employee Retirement Income Security Act of 1974, or ERISA, pensions were often seen as a personal expectancy rather than a property right. However, historical trends show that divorce courts were beginning to view these future payments as deferred compensation earned during the marriage. For a man who had worked 30 years at a factory or a corporate office specifically to ensure a stable retirement, the news that his pension was being divided was a psychological and financial death blow. He was being asked to divide a pot of money that he couldn't even touch for another decade. The step-by-step calculation of the present value of a future pension became a specialized field, often involving actuaries who would testify that a man's future security was worth a specific six-figure sum today, which he was then expected to offset by giving up his share of the family home. The inflation trap of the mid-1970s added a layer of cruelty to these financial arrangements. In 1974 and 1975, The United States was gripped by the Great Inflation. A dollar in 1970 was losing its purchasing power at an alarming rate. Men who had agreed to fixed alimony payments based on their 1970 income found themselves in a vice. Their expenses were skyrocketing due to inflation, but their support obligations remained static or worse, were tied to cost of living adjustments that didn't account for their own rising costs. This led to a historical trend of men filing for modifications of support, only to find that the legal fees to change the order cost more than the potential savings. They were trapped in a mathematical downward spiral. To counter these forensic strikes, men began to utilize more sophisticated legal help. This was the era of the closely held corporation maneuver. Historical trends show that men would attempt to shield assets by placing them into complex corporate structures, or by deferring bonuses and raises until after the divorce decree was final. However, the potential outcomes of these tactics were often risky. The Internal Revenue Service became an unintended third party in many divorces. If a man tried to hide assets from his wife, he was often inadvertently confessing to tax evasion. Forensic accountants would use the threat of an IRS audit as leverage, essentially telling a man that if he didn't agree to a generous settlement, they would turn his books over to the federal government. This was the ultimate financial silver bullet. The tax consequences of the 1970s divorce were also a minefield. Under the tax laws of the time, alimony was deductible for the man and taxable for the woman, while child support was neither deductible nor taxable. This led to the step-by-step negotiation of the alimony child support mix. A man's attorney would fight to label as much of the payment as possible as alimony to lower his tax bracket, while the wife's attorney would fight for child support to keep her tax burden low. The children, once again, were used as units of financial measurement in a high-stakes tax game. Imagine the mental state of the 1976 man. He had survived the surveillance of the 60s, the psychological testing of the early 70s, and now he was being dismantled by a man with a green eyeshade and a calculator. He felt like a ghost in his own life, watching as his career, his retirement, and his reputation were converted into a series of columns on a balance sheet. The help available to him was increasingly technical and increasingly expensive. He was no longer a person, he was a cash flow. This financial dehumanization led to a radical shift in the late 1970s. Men began to realize that no matter how much they worked, the system was designed to keep them in a state of perpetual provision without representation. They started to look for a way out that didn't involve hiding money or fighting experts. They started to look for a way to rewrite the social contract itself. They wanted a world where a man was valued for more than his net worth, and where a divorce didn't mean the end of his identity. As we reach the final chapters of this decade, we see the emergence of the modern joint custody movement, and the first successful challenges to the idea that a man's only role is that of a provider. But the scars of the 1960s and 70s divorce wars remain. They are etched into the laws we use today, and the ways we think about fatherhood and fairness. The battle was nearly over, but the final stand would be the most important of all. In the final part of this deep dive masterclass, we are going to look at the legacy of the 1960s divorce man. We will examine how these decades of legal combat created the modern American father. We will look at the final legislative victories that brought the 50-50 custody split into the mainstream, and we will provide the ultimate historical perspective on what it means to be a man in a system that has spent 60 years trying to define you. The war is ending, and the reconstruction is about to begin. The reconstruction of the American man in the wake of the 1960s divorce era was not a quiet transition. It was a total reimagining of the masculine role in society. As we enter the final years of the 1970s and look back from the vantage point of 2026, we can see that the men who survived the fault-based systems and the early no-fault wars were the architects of a new social contract. This was the era where the term breadwinner began to lose its status as the sole definition of a man's value. The Reconstruction began with a legislative pivot point in 1979 that would forever change the potential outcomes for fathers. That year, California, once again the laboratory for domestic law, passed the first joint custody statute in the United States. This was the result of a decade of intense lobbying by the very men we discussed in previous parts, those who had been relegated to the role of the weekend visitor and were no longer willing to accept that as their legal destiny. Historical trends show that prior to 1979, joint custody was almost never granted unless both parents were in perfect agreement, which was a statistical rarity in contested divorces. The new law created a rebuttable presumption that joint custody was in the best interests of the child. For the first time in American history, The law explicitly recognized that a father's role was equal to a mother's, not just in terms of his financial obligation, but in terms of his physical and emotional presence. Imagine if in 2026, after 60 years of the system assuming you were a secondary character, the law suddenly recognized you as a co-protagonist. This was the seismic shift that allowed men to move from the defensive posture of the 1960s to an active, engaged role in the reconstruction of their families. Step by step, the implementation of joint custody required a new set of tools. The first tool was the parenting plan. In 1965, a man was given a piece of paper that said when he could pick up his kids. In 1980, he was required to participate in a complex negotiation of schedules, holidays, and educational decisions. This was a new kind of help for men mediation. Historical trends indicate that the rise of mediation in the late 1970s saved men millions of dollars in legal fees. Instead of two lawyers fighting in a courtroom at $300 an hour, a man and his ex-wife sat with a neutral third party to map out the future. Case studies from this period show that men who participated in mediation were significantly more likely to keep their child support payments current, and were less likely to be involved in future litigation. They felt they had a stake in the outcome, rather than having a sentence handed down by a judge who didn't know their children's names. The Reconstruction also required a total overhaul of the financial laws that had kept men in alimony jail for decades. In 1979, the United States Supreme Court heard a case that would become the final blow to the Victorian-era support system, Orr versus Orr. The case involved a man from Alabama who challenged the state law that required only husbands to pay alimony. The Supreme Court ruled that such laws were unconstitutional, stating that the law cannot use gender as a proxy for financial need. This was a massive win for the legal consistency of men. It meant that alimony was no longer a gender-based penalty. It was a needs-based bridge. Historical trends following this ruling show a gradual shift toward rehabilitative alimony, temporary support designed to get the other spouse back on their feet, rather than the permanent, lifelong payments that had bankrupted so many men in the early 1960s. Consider the character of Arthur, a man we will place in 1980. Arthur is the bridge between the two eras. His father had been a 1962 divorcee who lost his home, his kids, and his career. Arthur, facing his own divorce in 1980, entered a different world. Because of the Orr versus Orr ruling, his wife, had a career of her own, was not entitled to permanent support. Because of the joint custody statutes, Arthur was granted 50-50 time with his two daughters. He didn't have to hire a private investigator to prove his wife's fault, and he didn't have to flee to a Reno ranch to get a decree. He was able to remain in his community, maintain his professional status, and continue to be a primary parent. The potential outcomes for Arthur were a far cry from the social exile of the previous decade. He was the first generation of the modern father, a man who could be a bachelor and a dad simultaneously, without the stigma of being a failed man. The corporate world also underwent a silent reconstruction. By the early 1980s, the stability index used by HR departments began to fade. As divorce became more common across all levels of management, it was no longer the career killer it had been in the 1960s. The organization man was replaced by the flexible professional. Historical trends show that companies began to realize that a man's productivity was not tied to his marital status, but to his work-life balance. Case studies of top-tier executives from the 80s show a rise in men who openly discussed their shared parenting schedules in the office, a move that would have been unthinkable for an IBM manager in 1964. This was the normalization of the divorced man, a process that allowed men to stop hiding their personal lives and start integrating them into their professional identities. However, the legacy of the 1960s divorce wars still echoes in 2026. The psychological scars of that era shaped an entire generation. Many of the men today who are most adamant about prenuptial agreements and legal protection are the sons and grandsons of the men who were decimated by the 1965 system. They saw the total liquidation of their family's wealth and the disappearance of their fathers, and they are navigating their own relationships with a historical caution. This data-driven caution is what has led to the current rise in pre-marriage planning and the professionalization of domestic contracts. We are living in the world that the 1960s built, a world where we no longer take the stability of the legal system for granted, and where every man is encouraged to be his own advocate. This deep dive masterclass has taken us from the dark hotel rooms of the 1960s private dicks to the sterile offices of the 1970s court psychologists, and finally to the landmark legislative halls of 1979. We have seen how men were stripped of their homes, their money, and their kids, only to fight back and reclaim a new definition of fatherhood and fairness. The historical trends are clear. The system didn't change because it wanted to. It changed because men organized, litigated, and refused to go away. They forced the law to catch up with the reality of the human heart. The reconstruction is an ongoing process. As we look toward the future of domestic law in the mid-2020s, the lessons of the 1960s serve as a warning and a guide. We know now that a system built on fault and punishment creates only losers. We know that children need both parents, and that a man's identity is not a ledger to be balanced by a judge. The help that was once sought in the desert ranches of Nevada is now found in the shared parenting apps and the mediation rooms of modern America. We have moved from a culture of combat to a culture of coordination, but the cost of that transition was a generation of men who had to lose everything to prove that they were worth something. But even as the laws of the land have reached a state of relative equality, a new shadow is falling across the domestic landscape. As we master the complexities of joint custody and asset division, the digital age is introducing a new form of surveillance that would make the private eyes of 1960 look like amateurs. The battle for privacy and the protection of a man's digital footprint in the 2020s is becoming the next great legal frontier. In our next deep dive series, we will transition from the historical to the high-tech. We are going to explore the rise of digital discovery in modern divorce, how your smart home, your fitness tracker, and your browser history have become the new star witnesses in the 2026 courtroom. The war for the mind and the home is evolving once again, and the rules of engagement are being rewritten by the very algorithms we use to run our lives. The masterclass continues.